Now, I am going to dictate a legal passage based on latest Supreme Court judgment at the rate of 120 words per minute. Let's start.
The jurisdiction of the appellate court in dealing with an appeal against an order of the acquittal is circumscribed by the limitation that no interference is to be made with the order of the acquittal unless the approach made by the lower court to the consideration of the evidence in the case is vitiated by some manifest illegality or the conclusion recorded by the court below is such which could not have been possibly arrived at by any court acting reasonably and judiciously and is therefore liable to be characterized as perverse, where two views are possible on an appraisal of the evidence adduced in the case, and the court below has taken a view which is plausible. One, the appellate court cannot legally interfere with an order of acquittal even if it is of the opinion that the view taken by the court below on its consideration of the evidence is erroneous. The court has repeatedly laid down that the mere fact that a view other than the one taken by the trial court can be legitimately arrived at by the appellate court on
The appraisal
of the evidence cannot constitute a valid and sufficient ground to interfere with an order of acquittal unless it comes to the conclusion that the entire approach of the trial court in dealing with the evidence was patently illegal or the conclusions arrived at by it were wholly untenable. While sitting in judgment over an acquittal, the appellate court is first required to seek an answer to the question whether the findings of the trial court are palpably wrong, manifestly erroneous, or demonstrably unsustainable. If the appellate court answers the above question in the negative, the order of acquittal is not to be disturbed. Conversely, if the appellate court holds for reasons to be recorded that the order of acquittal cannot at all be sustained in view of any of the above infirmities, it can then and then only
reappraise
the evidence to arrive at its own conclusions. There is no embargo on the appellate court reviewing the evidence upon which an order of acquittal is based. Generally, the order of acquittal shall not be interfered with because the presumption of innocence of the accused is further strengthened by acquittal. The golden thread which runs through the web of administration of justice in criminal cases is that if two views are possible on the evidence adduced in the case, one pointing to the guilt of the accused and the other to his innocence, the view which is favorable to the accused should be adopted. The paramount consideration of the court is to ensure that miscarriage of justice is prevented. A miscarriage of justice which may arise from acquittal of the guilty is no less than from the conviction of an innocent. In a case where admissible evidence is ignored, a duty is cast upon the appellate court to reappreciate the evidence in a case where the accused has been acquitted for the purpose of ascertaining as to whether any of the accused committed any offense or not. See Bhagavan Singh versus State of MP within the 2002 for SCC 85. The principle to be followed by appellate court considering the appeal against the judgment of acquittal is to interfere only when there are compelling and substantial reasons for doing so. If the impugned judgment is clearly unreasonable, it is a compelling reason for interference. These aspects are highlighted by this court in Shivaji Shabarao Bobade versus State of Maharashtra within bracket 1973 2 SCC 793. Ramesh Babulal Doshi versus State of Gujarat within bracket 1996 and 9 SCC 225. And Jaswant Singh versus State of Haryana within bracket 2004 SCC 484. Stop. Thank you.